My name is Azmairnin Jadavji, founder and president of Pardon Services Canada. I want to speak to the proposed amendments to the Criminal Records Act contained in Bill C-23, which would change the way pardons, soon to be called record suspensions, are granted. These changes would see longer waiting periods and place further restrictions on eligibility. Some of these proposed changes are an emotional response to a couple of high-profile, sensational cases. It is time to consider the proposed amendments in a calm, rational manner. Bill C-23 seeks to increase eligibility periods. In the case of indictable convictions, the wait time would double from 5 years to 10 years. It also seeks to disqualify people guilty of 3 indictable offenses from ever being eligible for a record suspension. More than 3 million Canadians have a criminal record. Most of these are now law-abiding citizens. We're speaking of family people, hard-working men and women who have made a mistake in their past. The current system provides them relief, allowing them to reintegrate and live productive lives free of obstacles. The system has strict eligibility criteria, and it is working. Since its inception in 1970, only 3% of pardons have been revoked because people reoffended. Increasing eligibility periods is more likely to negatively impact society than to benefit it. People should not be held back. Everyone makes mistakes. It is time we distance ourselves from the highly emotional cases and look at some typical scenarios. Take, for example, a 19-year-old who gets caught with possession of drugs or shoplifts and is sentenced to 1-year probation. Under the new proposal, this young person would have to wait 11 years after his conviction to apply for a record suspension. This means he would not be able to obtain meaningful employment as a firefighter or a nurse or a lawyer, or to travel freely until he is 30 years old. This is unreasonable and contrary to the spirit of the original law. Look at another case, a 23-year-old who breaks into a cabin. This person could be convicted with breaking and entering, theft, and possession of stolen property, 3 indictable offenses. Under the proposed legislation, this person could never apply for a record suspension and would have to live with the obstacles of a criminal record for the rest of her life. In terms of the public outcry regarding sexual offenders, we point out that only 2% of criminal convictions are for sexual offenses. Of these, only a small portion relate to offenses which would disqualify offenders from ever receiving a record suspension. It is unreasonable that this small minority of offenders should cause the revision of a system which otherwise has worked well since the 1970s. We have written to the Minister responsible and other members of Parliament and will keep you informed. If you have any concerns, questions, or would like to add to the debate, please contact us. Thank you.